of Appeals, the Queen on the application of Plan B at Limited, the Queen on the application of Friends of the at Limited, the Queen on the application of London Borough of Hillingdon and others, the Queen on the application of Heathrow of Limited and another, and Secretary of State for Transport and others.
Lord, I rise first because in order to comply with your instruction on the witness statement, produce the witness statement, I wanted to mention that now I'm trying to get it before he watches for Mr. Humphrey's reasons. It has attached, make no submissions on it, save to express an apology. Paragraph 15 of Mr. Sainsbury's third witness statement says, I cannot recall which of the composite plans is handed up to the division report. Having thought about it, my recollection is a bit shady as well. I think I handed up the wrong plan.
Oh, did you?
Yesterday, if you go to the exhibit, you will see the mock-up plans are first, and afterwards are some slightly neater plans. And just to tell you what they are, page 3 is the westerly operations, and to the left of the departures, to the right arrivals, and the opposite for the other page. So insofar as necessary, I'll make conditions of the plan.
Yeah, I mean, it's not easy. It's not easy to read, actually. Does it matter that it's not easy to read these?
This one.
That one is, I think.
The other one it can be either thrown away or ignored. It was the one I thought I'd handed up to the division court, and I probably didn't. And this one needs to be read with Hal's version as well, because it's just a composite, but without the bands for height.
I see. So we need to focus on page 3, not pages 1 and 2. Is that right? But they all form the same exhibit.
Yes, because you asked who had prepared.
Yes.
All right. The second one is rather neater. It's prepared by the London Borough of Wandsworth, and you see he refers to that.
I see. Yes. Well, I haven't yet read the witness statement. No. All right. Thank you very much. If we have any queries on that, we'll raise them with you. Thank you. Yes, Mr. Marici.
I'm going to finish dealing with habitats, and then, which I think to do relatively shortly. I'm then going to move on to SCA, and what I was reading to Humphreys is that come 12 o'clock, I'll find a convenient moment and allow him to pose his submissions. That will leave me with half an hour after lunch, assuming Mr. Humphreys is an hour.
Yes. Well, we will make sure that your time is not taken from you, Mr. Marici.
Great. Well, in terms of habitats, I've largely covered what I wanted to say. There are two things I wanted to go back to in the note. First of all, it's all on page 3, slightly over to page 4. In dealing with the hub objective point, which I was making submissions on yesterday, we did jump forward at the top of page 3 to then cover the SEA versus habitat point on page 4. I was kind of take you back to, if you look at paragraph 23, and then I, and you've got a series of Roman numerals, reference to Caroline Lowe's witness statement. Could I ask you, please, to go to Caroline Lowe's witness statement, which is volume 6, and to go, please, to page 218 to start with.
Yes.
Well, just a handful of paragraphs I want to show you. It's really a confirmatory of submissions I've already made about what was going on in relation to the hub objective. If you go to page 218 in volume 6, you'll see paragraph, this is in a section I should say starts on page 216 under the heading habitats. And at page 435, Ms. Lowe introduces the fact that there are 2 reasons for ruling Gatwick out, and the text in the AMPS, insofar as it dealt with draft HRA, between the February and October versions. And then she turns to explain that, when if you go to page 220, it's really paragraphs, I was going to ask your Lordship to read 442 to 444. You're happy to read it yourselves while I read them out.
Yes.
that sets the context for and is entirely consistent with what one sees in the submission to ministers that was referred to by Mr. Fleming yesterday, which I'll briefly touch on in a moment. Models, I've also given you the reference, I don't ask you to read them now, to paragraphs 446 and 447, where Ms Lowe draws these points together. But Models, can I ask you then to just jump forward to her second witness statement in the same bundle, page 525. There's just two paragraphs there. Again, you've got the references for in the note, and I was going to ask you to read these to read yourselves, which is on 525, it's paragraph 67, and then 69 comes over the page.
Yes.
And then you'll see that in the note, after I've given you those references, I don't ask you to go to it now, but we've actually got an extract from Gal's representations where you can see the arguments that they were making consistent with what has been summarised by Ms Lowe in those paragraphs about how they hub status were overrated or that they could meet the hub status. And then, well, I was going to ask you to leave volume 6 out because I'm going to be repeatedly coming back to the witness statements. But can I ask you, at the risk of having too many documents out, to take out, in terms of the ministerial submission, that's volume 9. I've given you a number of references, and in fairness to Mr. Jaffe, he did take me into almost all of these, so I'm not going to go back through them. Obviously, I asked you to read it as a whole, but I'm going to ask you to go to page 1710 in bundle 9.
Yes.
This is an annex to the submission. And obviously you've seen a number of the paragraphs in the submission already. 14 on page 1703 is one that we emphasise, uses the language around threaten hub status. But 1710 is a different point. You weren't taking this, but I did mention it yesterday. Paragraph 2, impact on the appraisal of sustainability. So what's the impact on the AOS if the view is taken that Gatwick is not an alternative under the Habitat Directive? And 2 says the AOS includes an assessment of reasonable alternatives undertaken in order to meet government's obligations under the Planning Act and the regulations. As set out in the government's guide, the assessment of reasonable alternatives under the SEA is an iterative process. Alternatives need to be considered as the plan programme evolves. It also confirmed it's not the purpose of SEA to decide the alternatives to be chosen for the panel programme. The SEA provides information on the relative environmental performance of alternatives and can make the decision-making process more transparent to predict environmental effects. Therefore, the alternatives are used to test the evidence underpinning the preferred scheme and to help demonstrate how the tests of soundness have been met. This is a distinctly different process and concept. Yesterday, we need to get back to it now.
Paragraph.
Paragraph. I think it's references to where the judgment deals with both Caroline Lowe's evidence, so I can show you, but also the ministerial submission. So that's the last reference before we get to Mole Valley. And in due course, I don't ask you to do now. I ask you to look at the facts that were found by the divisional court on the ministerial submission and how it fitted in. Then can I then turn to Mole Valley SAC?
Is it actually called Mole Valley SAC or Mole Gap SAC? Mole Valley is an administrative district.
It's probably Mole Gap. It's Mole Gap. So
it's been variously referred to so far, but is it actually the Mole Gap SAC?
Well, we're going to come up.
Well, don't spend time.
We'll all the references in a moment, so perhaps we'll see it there.
All right.
Well, it's just by way of, what I want to do on this is I want to just raise a couple of points by way of background. Then I want to show you what the actual pleaded case was from the boroughs on this point, and then what the evidence was, and where that led the court.
Yeah.
So in terms of background, can I ask you, I think I've probably just volume 7. So this is the reference at 24B2. It's volume 7, page 1027. Volume 7, 1027.
Right, just a second.
And I will pick up on 1027. Well, I should just say on my note, 24B Roman 2 1. That first reference should be to paragraph 9.2.11, not 9.1.11. Well, did you see in 9.2.11 the actual title is Mole Gap to Reigate Escarpment SAC?
Oh yes, right.
It's a catchy title, but that's
Well, we'll call it the Mole Gap.
Mole Gap, I think.
Yeah. Okay. Let me just get where we should be. Yes. We were looking at this yesterday,
Well,
weren't we?
we were, and Mr. Jeffy showed you the first part of 9.2.12, and he stopped, I think, about 3 lines from the bottom, and the submission he made was that the sole, or perhaps the principal reason given, this is the 8th, we are of course in the, this is the document which is called Statement to Inform the Integrity Assessment, it starts on page 1003. The
Yes.
submission he made was that the only reasons being given here were related to the potential position of the Commission, because you need the Commission's opinion, etc. But once he stopped reading 3 lines from the bottom, can I just take you to the 3 lines from the bottom of 9.2.12? Having dealt with the Commission point, it then says this: in Sweetman, the European Court said that maintaining protected sites in a favourable status was particularly important where there was a priority species habitat. And in Commission and Spain, it was said that under the Habitats Directive, Member States must take appropriate protective measures to preserve the characteristics of sites which host natural habitat types and or priority, and should generally avoid intervention where there is a risk that the ecological characteristics of those sites will be seriously compromised as a result. So in terms of the background, yes, the Commission point was raised, and I'm going to just return to that in a moment, but they're also making the point that even if you've got Commission approval for gathering, necessarily what you're talking about here is potentially harming a site that hosts priority species. And the European Court has obviously given particular emphasis to the fact that those sites should be protected because they do host priority species. And we'll note the way it's put, which is the correct way. It's the site that's designated and protected because it hosts priority species. It's not actually the priority species that is protected in this regard, it's the site. So what we're talking about here is harm to the SAC. And well, the reason that's relevant is it's not appropriate, and we'll see this in the evidence in a moment, it's not appropriate to say, for example, well, in a 200-metre strip running from the road that you're going to put traffic on, there is currently no protected orchids, for example. That is part of the designated site, and therefore it is to be protected. The fact that its current management or the current environmental conditions might mean that there are difficulties for that protected species doesn't end denouncing. So that is an important point I'm going to come to with the evidence. Right. So that's the background. In terms of the Commission point, can I just close that one off? Well, in the judgment 295, let me go to it, the court rightly records my concession that it wasn't necessary as a precondition to obtain the Commission's approval for Gatwick as an alternative. That's judgment 295. But in addition, the judgment at 369, let me just look at that, which we did, I think, look at yesterday. The 369, that wasn't the end of the Commission point. So on 369, it starts about 3 lines down. Mr. Marici accepted this procedural requirement did not itself prevent Gatwick scheme from being considered as an alternative, not least because it did not amount to a precondition that the Commission's approval be obtained. Well, that's also recorded in 295 judgment. But, as Mr. Morrison said, even if an opinion had been sought in connection with the ANPS, there's no reason to think it would have been favourable, because any such opinion would normally be linked to detailed conditions regarding compensatory schemes. Mr. Marici rightly pointed out that the level of detail needed for this purpose would not exist until the production of detailed designs at the project stage. Thus, the reference to obtaining an opinion from the Commission did not detract from the essential judgment that on the information available at the stage preparing the ANPS, and applying the required proportionate approach, the adverse impacts on the Gatwick second runway scheme could not be discounted. So, my Lord, the Commission point was relevant, but wasn't the essential point. And, my Lord, I've given you one other reference on the Commission. This is 24C2. I don't ask you to go to it now. That's back in the Commission guidance, which I showed you yesterday. And that guidance confirms you don't need the Commission's approval to harm a priority site using Article 6.4. You need their opinion. And if you disagree with it, what is said by the Commission is you have to give reasons to explain why you disagree with it. Because obviously it's an important consideration that the Commission don't agree. In addition, what the Commission say in that document is that allows the Commission then to consider whether to take infraction proceedings if they don't agree with your assessment. So if you're actually thinking about whether something is an alternative, the fact that there is this process with the Commission is certainly a relevant consideration. Well, that's enough on that Commission point. Can I just finish off this moral gap point? Well, first of all, the pleaded case, 125, the pleaded case was no evidence. The Secretary of State had no evidence to support the conclusion that there was a potential ecological harm to the moral gap in Gatwick. Well, I've given you over the page, and I've mixed up the B and C. I've mixed up the documents and the references. So the borough's pleadings are actually CB2 61011, and the agreed list of issues is actually CB2 651. I don't ask you to go to that.
Sorry, just pause. I know you've got a lot to cover, but let's just get this right. In your references, the references are the wrong way round.
Yeah, D and C are the wrong way round.
All right. Thank you, yes.
Effectively, I don't ask you to go to them now, but the pleaded case is very clearly no evidence. And indeed, the parties were directed by Mr. Justice Holgate to agree the list of issues that arose, and you'll see in that list of issues, the issue was whether our decision was flawed on the basis of no evidence. And that's the way the judgment also, if you did A, the judgment also characterises rightly the pleaded case of the boroughs to be no evidence. And I don't have to just have to do one thing, which is to show you just an example of what the evidence was. This is, if we go back to bundle 6, page 443.
Just a second.
Two paragraphs in Mr. Morrison's first witness statement. I'll take your lordships through.
443.
443, now, yes. These are the references you put in the note of 26p, Roman 24. But model 3.33.9, first of all. Gal objected to the assertion in the HRA of significant impacts from their scheme on priority habitats occurring within the mole gap, and the conclusions drawn from that section. Gal referenced the survey completed on their behalf. Gal stated the results of the survey had been presented to Natural England, and it was agreed that the survey demonstrated there was no priority habitats in the area that might be affected. And when you look at our agreed narrative events in due course, you'll see that that survey was done in June 17. But the survey was actually only sent to the department by Gatwick in December 17. So after the ministerial submission, you see, September 17. That's all recorded in the agreed narrative. And then 3.33.10, WSP, so that's the department's ecological consultants, responded to the GAL survey. And you'll see there the footnote that it only came in December. That's what it's recorded as part of the December submission. It was undertaken in June 17, included the area of the SAC falling within 200 metres of the M25. And that's the road that Gatwick would put extra traffic on. The survey identified that no orchid species that would meet the criteria for priority habitat were identified in this 200 metre zone during the survey, despite suitable grassland habitat being present. And we'll remember is that we're actually protecting the habitat and the site, not just the orchid. WSP noted that Gal concluded that the grassland within 200 metres identified was in a condition unlikely to support rare orchid species due to the current management regime necessary to balance the requirements of open public access and biodiversity interest. Gal also concluded that there were no plans to change the management of the area for the foreseeable future. There's also potential for an increased traffic on the M25 as a result of Gatwick to have a significant effect. So therefore there is no potential for that impact from Gatwick. And goes on, WSP responded that this assessment did not provide sufficient regard to the precautionary principle. So that's the principle we were applying for both sites. As acknowledged by Gal, orchids are notoriously sporadic in their appearance, and 2017 has been poor for some species due to the relatively dry winter. In addition, naturally they have clarified through consultation response that it had already been stated that a lack of orchids reported in 2017 does not mean they have not been or could not be present. And further to this, naturally requested that Gal caveat that there's currently very little potential for orchids to occur in this area. This is opposed to the site having no potential, and it's acknowledged in the Gal report, and it's agreed to consultation with England, that orchids are unlikely to present despite suitable annex or habitat being present. However, this is quite clearly caveated as being due to current conditions, including visitor pressures, cattle grazing, rabbit grazing. WSP concluded that on the basis of the evidence presented, that under current conditions there is some potential for orchids to be present, and missed due to survey limitations and due to their sporadic nature. It's recognised as potential limited on the basis of the advice of Natural England National Trust. However, it's clear from the report and the consultation response that the absence of the habitat priority habitat is likely to be attributed to the current management regime, and with more favourable management, it's considered possible that the future baseline could change and support relevant orchid species and populations. The GAO report appears to suggest the current regime is effective and sensitive, but WSP queried this assertion, given that it's also reported that the Land is Crow Act, therefore the public have a right to graze on foot. However, horses, bikes and fitness groups use the area. Obviously then that wouldn't be part of their entitlement. And rabbit control is difficult in this area that is so heavily used by the public. So the position taken was that there was some potential for orchids to be present. But in any event, we're talking about protection of a site that hosts priority habitat species. This is a site that has been designated as hosting that priority species. And it's not possible to simply say, because you've, on a survey that was undertaken a very limited period in 1 month, say there either are no orchids in that area, or even if there are no orchids, that is determinative. That's not the way one would analyse this, applying a proper precautionary approach. And then, my lords, we'll also, if we just flick forward to 455 in the same witness statement, and then I'll move on from this point. You'll see at 4.25, it's also said by Mr. Morrison that notwithstanding the above conclusion, that there's potential for important orchid sites to be present within Unit 25. So that's the unit we're talking about. But therefore guidance should be considered with regard to the wording of the directive. If the site hosts priority habitat species, therefore advise it should be interpreted as if, i.e. if the site has been designated, at least in part, due to the presence of a priority species habitat. This takes into account the presence or absence of orchids is not the correct criteria against which the assessment should be undertaken. Well, as I'll leave that there, I have given you, at 26E, 2 other references to Mr. Morrison's second witness statement, which further support that same line of reasoning and evidence. And so my conclusion is that what the court found, and it's paragraph in the judgment, paragraph 368. 368 in the judgment. Yes, 368. The upshot, put away, obviously the witness statement at the moment, but the judgment 368. The upshot is that we are unable to accept the potential that there was no evidence before the Secretary takes the court conclusion that potential significant effects of the SAC arising from the Gatwick 2R scheme could not be ruled out. And that was what the court understood to be the pleaded case. And then, just to note, over the page 370 and 371, the court posed a question about something that was said we had not fully explained. That's the subject of our respondent's notice. I've given you the reference to where we deal with that in our skeleton, 27C. But in the end, none of that mattered, because 371, the court said, ground 8.2 was not put in that way. And it wasn't, because as we've seen, if you look at the pleadings and the brief issue, the issue that was agreed was our decision unlawful on the basis there was no evidence to support the conclusion of ecological harm. Now, my lords, we do say, court in 370, if necessary, we say, didn't get it quite right there, and we've given our explanation of our answer to that question. But, my lord, none of that arises on the borough's pleading text. So, well, that's all unless I can assist you further, that's all I wanted to say on habitats. I have put some references at the bottom of the note on our position on a reference to the European Court, but I think you know we oppose a reference at this stage. We've made submissions in the scope of an argument about why we oppose it. But of course it would have to be, before your Lordship's discretion to refer arose, you'd have to decide that it was necessary to refer. And the first question that a reference is sought on is a standard of review in habitats. And my lords, in my submission, if you did make that reference, and I say you shouldn't, the answer you're going to get back in my submission is going to look something pretty similar to what the European Court said in Craigest, which is effectively these are matters for the National Court unless it's directed by legislation. That's the good answer I suggest that you get. And well, as I've given other reasons why we say a reference would not be appropriate at this time, I'm not going to labour that. Well, can I, unless I can assist you further on that, turn to SEA, and I have got my hand up to the court.
Right.
I've got a note, again, some references.
Thank you.
My lords, it will be worth having out both the judgment and volume 6 at hand, which is the witness statements, because I think we've got to go to those, multiple times.
Right.
And I've got a lot of ground to cover, and I'm intending to take it relatively quickly. I've tried to give as many references as possible to help the court through. So, well, paragraph 1, just a note on the nature of the directive.
Yes.
We all refer to it as the SEA directive, the Strategic Environmental Assessment Directive. But what the Commission guidance and the Supreme Court and HS2 pointed out is that's not its title. Its title is actually a directive on the assessment of certain plans and projects. And we call it, to shorthand, the SEA directive because it's focused on strategic level decision making, at that higher level decision making. And then there's a second point that's key here is the definition in the SEA directive of environmental assessment has two elements. The environmental report, but also the consultations on that report and the taking into account of the responses. So the assessment is not just the report, it is also the information that comes to the decision maker through the consultation process. And well, that links directly to Blewett on EIA, where exactly the same observation was made about the very similar legislation in the EIA context by Mr. Justice Sullivan at paragraphs 39 and 41. I don't go to Blewett now, we may need to touch on it later. And while here, you've got extracts from the main AOS report, which is very lengthy, even in terms of the extracts, and then a number of the appendices, which in themselves are also very lengthy in terms of what's before you, about 350 pages. That's not all the appendices. And well, the overall purpose, as stated, was to give a strategic level assessment of the ANPS. So, well, I'd ask you just to note that reference I've given you at 1.45. The SEA, the AOS, looks at the impacts of the three shortlisted schemes without mitigation. So that's the task that's set. You don't look at mitigation, you look at the overall harms from the three schemes without mitigation. There is a section later on in the report that looks at possible mitigation, but the actual assessment of impacts is done without mitigation. And then what was unusually here, the AOS followed on from and built on extensive work done by the Airports Commission. Well, I don't ask you to take it up, but that's it. I've given you all the references and the evidence to that, and also it's covered in the judgment, giving you the references to that. But well, at C, I don't ask you to take this up, but that's a reference to a document that's in the bundle, produced by the Airports Commission alongside its final report, called Business Case and Sustainability Assessment. And in those references I've given you, what the Airports Commission explains is that obviously they weren't required to do SEA, because they weren't adopting plan or programme, but they knew that once the Secretary of State proceeded to take forward their recommendation, changes that he may well need to. And therefore they have tried to do a large amount of work in advance on what an SEA would require. So the Secretary of State would have a head start in terms of the work for the incentive. Then my Lords, 7, similar to habitats, there was a cross-government working steering group on the AOS with various departments, including DEFRA, DEC as it then was, Energy for Climate Change, Natural England, etc., who throughout provided advice on the content. 8 WSP had experts for each chapter. 9 WSP looked at other MPSs and followed industry standards and existing good practice. And I've given you the references to that, but I'll just 2 things on that. The AMPS is the 12th national policy statement since the Act came into force. So there is a considerable body of practice amongst professionals to undertake assessments. And my Lords, the AMPS is also not the first site-specific AMPS. The nuclear MPS was site-specific, and that's one that Ursula Stevenson in her witness statement draws particular attention to. But also the wastewater MPS was site-specific. That was the one that supported the Thames super sewer. So, my Lords, there's a body of established industry practice and good practice around MPSs. And then, my Lords, the AOS involved, this is point 10, thorough and careful analysis. And I've given you a handful of references to Ms. Stevenson's witness statement. Can I just take up one of those, if I may? First of all, could we go to page 249 in the bundle 6? My Lords, at 2.34 and 2.35, I won't read it now, but what's explained there is that there was an interaction, as there should have, between the content of the draft policy statement and the AOS. So they influenced each other. And WSP, as well as producing the AOS, were also making comments and helping with the drafting of the policy in order to frame things like mitigation, etc. And well, that's really, as we say at 10B, this is how it should work, and that was the point that was made in Seaport and in Ms. Justice Singh's suggestion was in Cogent. And well, I'll come to, I know you should ask me whether that had been approved in no data, I'll come to that a bit later on. The answer is, in my submission, it has been. There's a one paragraph that does seem to pick up that particular point. So, my Lords, we then, if we could go forward in the witness statement, well, the next reference I wanted to show you was 265. This is just to give you some flavour of the scale of the exercise that's undertaken here. But 3.14 tracks through some of the key stages of the work. So 3.14.1 was a gap analysis to look at what the Airports Commission had done and to check whether that was good enough, was anything missing, etc. And then 3.14.3, as with EIA, there's a requirement to scope your report. So you have to issue it to certain statutory defined bodies, Natural England, the Environment Agency, and you have to consult with them on what your scope, what your AOS should contain. And that's what happened here. And then 3.14.5, perhaps unusually, but because of the scale of the project, the sub-consultant was hired, clearly, with considerable experience in SEA in order to provide reviews throughout the process. So a sort of second review, sort of quality review, by another consultant.
Peer review?
Peer review, my Lord, would be, yeah, a very good way. It's a peer review by clearly. And my Lords, I won't go into any more detail on that. There is, in my submission, an excellent summary in one paragraph, judgment 441, of the whole SEA process. The original court reduced our extensive evidence to that one paragraph, and it's an excellent summary.
Right, should we look at that?
Well, my Lords, yes, we can have a look at it.
Well, unless you...
Well, my Lords, I was going to ask if you could, due course, it's quite a long paragraph, I'm happy for you to read it now.
Yes.
I won't read it out.
Unless you want just to give us the reference and
Well,
we'll read
the
it.
reference, I've given you the reference in the note. I'm probably happy for now that your Lordships are to leave you to read that in due
You
course.
commend that to us
I do commend that to you.
as a summary.
And you'll see the very last point it makes is about the use of the language, provide independent peer review by clear lead. That's one of the points. Well, as the next point in the note is consultation. So the AOS in draft was consulted on twice, as you know, And the point is raised, I've given you the references, I don't ask you to take it up, but Mr. Thigh, who's one of the witnesses for the boroughs, explains that, for example, the boroughs did raise issues about the SEA. They said, for example, you haven't considered these community impacts. And that was something the government responded to. There's reference to this in the consultation response. I've given you the references. But also, as Mr. Stevenson does explain in a witness statement, there were some changes made in relation to certain subject matters in response to the borough's representations. And well, this is how AOS is supposed to work. And remember, these consultation responses form part of the assessment, not just the report. And then, well, this is an important point, given that we're about to come to the legislation. SEA is not the end of the road, by any means, for environmental assessment. There are 3 levels more assessment. Obviously, first of all, there are the EIA requirements at the BCA stage. These are important, because I say they are effectively being referenced in Article 5.2 of the SEA directive that we're going to look at in a moment. Secondly, local impact reports. Well, can I just briefly introduce those by reference to those 2 paragraphs of the judgment? So 35 in the judgment.
35.
35 in the judgment. Well, this is a feature of the Planning Act 2008 that doesn't exist in the 1990 Planning Act. But paragraph 35, you'll see 5 lines from the bottom. Section 60 sub 2 of the 2008 Act provides where a DCO application is accepted for examination, there's a requirement to notify any local authority that the area on which the land subject to the application concerned relates, and that would be Hillingdon, and where the land to be developed is in London, the GLA, the mayor, inviting them each to submit what's called a local impact report. And that's a report that needs to set out what all the local impacts would be of the proposed development. And of course, those reports, not surprisingly, often focus on the local plans for those areas. That's a way of analysing and channeling what the impacts would be. And at 37, you'll see the court sets out section 104 of the Act, which we've seen a number of times before. Well, if you go to the page, you'll see that sub 2b, one of the things the Secretary of State is mandated to consider, to have regard to on the DCO application, is any local impact report. So that's another level at which, well, this is particularly relevant to the local plans ground challenge, that there is a particular mechanism under this Act for channeling and dealing with these local impact issues at the next stage. And then, thirdly, in the note 12C, there's also a separate requirement for Heathrow to obtain, in due course, airspace change approval for the new runway. And as explained in Caroline Zodel's witness statement, I don't ask you to take that up now, but I've given you the references. That is itself subject to both consultation and environmental assessment processes. So there'll be a whole separate round of consultation and environmental assessment on airspace change. And then, as I turn in the notes to standard of review, and EIA, where one challenges the content of the environmental statement, the review is on the basis of Wandsworth. Well, that's Blewett, that's approved by the House of Lords in Edwards. And it's agreed in the list of issues that that is the test for EIA. And I've made the point that logically that doesn't fit with the submissions that have been made by both Mr. Jaffe and Mr. Taylor about Crayness. Because if Crayness had the effect of displacing the Wednesbury test in all cases involving environmental protection, then it would also displace it in relation to EIA, and they don't suggest that it has. They've agreed that that is the test. And then I'll come to the cases in a moment, but I've referred to a number of High Court decisions which support that same test applying the SEA directive, and I'll come to at least one of those in a moment. And then 15, we do say that EIA and SEA are very similar processes, and the boroughs argued below that there was a fundamental difference between EIA and SEA. And at A, that was rejected by the court at 460 to 418. And we say rightly so for the reasons that we get. And there's other support for that view that EIA and SEA are actually very closely aligned. Walton, that I've given you a citation to there, talks about EIA and SEA being complementary by referring to the European Court decision on Maidenhead. And then, well, as I just mentioned HS2, because yesterday in his oral submissions, Mr. Fleming said that the Supreme Court indicated that there was a difference, a significant difference, between alternatives in the EIA and SEA directive. And it's true that what the court said was that the difference between those directives is significant principally because of the different way they treated alternatives. And well, as Mr. Fleming said, oh, well, that means that you could take that, extrapolate it, that these directives are very different. No, these directives are very similar, apart from the way in which they deal with, or used to deal with, alternatives. And well, the reason I say that is, you will know that under SEA, the requirement has always been for reasonable alternatives. But up until recently, the EIA directive only requires assessment of alternatives that had been studied by the developer, the applicant. So it didn't matter whether it was a reasonable alternative. If you as the developer hadn't considered it, you didn't have to assess it. Well, in actual fact, you may know the EIA directive has been amended to bring it slightly closer to the SEA directive, and that's considered in the Holohan case that you've got in the bundles. And my lords, I've also referred to the Commission guidance, so I don't ask you to take it up, but there the Commission draws the conclusions that these directives, SEA and EIA, have related purposes, conceptual similarities, and should be interpreted in a similar way. So these are, in my submission, in accordance with what was held by the court below, very similar directives, and there should not be a different standard of review or approach to each. And I'll try and come to then a key point at 16. The boroughs refer to the requirements, for example, in Annex 1A and C, to look at the relationship of plans and programmes, or to identify areas likely to be significantly affected and their characteristics, as mandatory requirements. That's the way it's put. Or, I think it's also said in the skeleton, I've given you some of the references to this in the borough skeleton, 59, 60 and 63, or as hard-edged legal requirements. So it said these requirements in the annex are hard-edged legal requirements. And why would I say no, for the reasons that we can pick up from the judgment. And if you go to the judgment by Rules 388, looking at the legislation which is set out by the court, first of all, Rule 388, we start with Article 5.1, the requirement for a report. 389, the court deals with the fact that the information to be provided under Article 5.1, in the report, is subject to 5.2. So this is Annex 1, subject to 5.2. And then you've got the list of points, and obviously Mr. Fleming relies on A and C principally here. But all of that is subject to 5.2, and 5.2 appears in paragraph 390 of the judgment. The environmental report prepared pursuant to paragraph 1 shall include the information that may reasonably be required. So it's not a hard-edged legal requirement. It's not a mandatory requirement in that sense. A judgment must be exercised by a decision maker about what is reasonably required to be included under those heads. It's not every piece of information about the outline of the contents of a relationship between the MPS and plans and programmes. It's what the decision maker thinks is reasonably required. So it's a judgment expressly put on the part of the decision maker, and then it goes on, taking into account current knowledge and methods of assessment, the contents and level of detail in the plan. So if the plan's, because it's strategic, not got so much detail, that may affect what you can assess. It's stage in the decision-making process. And then this, which is emphasised by the court, and the extent to which certain matters are more appropriately assessed at different levels in that process in order to avoid duplication of the assessment. In other words, that must mean, in my submission, that a judgment has to be reached about whether something needs to be assessed fully at the SEA stage, or whether it's more appropriately deferred to the next stage, which is the EIA stage. That must be what is being referred to there, different levels in the process and to avoid duplication of the assessment. I.e., is it not really feasible to carry out fullest possible assessment because you're at the strategic level? Is that something that's better left over to the EIA stage? And so a judgment that has to be reached when designing your AOS is how much can you reasonably deal with now? And in particular, are there things that are properly deferred to be considered at the stage? And the court then draws that.
Just before you leave that,
Yes.
forgive me, Mr. Marici, in 390 and 391, particularly lines 3 to 5 of 391, the obligation is only to include information that may reasonably be required, which connotes the making of a judgment by the
Yes.
plan-making authority. Well, one can understand that, but at the end of the day, who is to decide whether something is reasonably required? I mean, it rather suggests it's an objective question.
Well,
Usually, the court forms a judgment about what's reasonably required.
Well, in my submission, it can't be the court in this situation because we can test it against some of the points that are being deployed by Mr. Fleming. So, for example, Mr. Fleming deploys this point around whether the contours should have been 51 or 54 dBA Q60 hour. Well, how can the court reach a view itself about what is effectively an issue that's in technical dispute between the two noise witnesses before this court? So, in my submission, what it's doing is it's giving the judgment to the decision maker to decide what's reasonably required. The court's review, naturally following from that language, must be on a Wednesbury basis. In my submission.
So the court decides whether the judgment exercised by the decision maker was a reasonable judgment. The judgment being that it was reasonable to require certain information.
Yes.
And that's Wednesbury. That's a Wednesbury standard of review to a question which itself has an inherent question of reasonableness about it.
It does, but my lord, it's perhaps not that different from when you have wording along the lines of the minister shall act if he considers it appropriate to do so. The review is still on Wednesbury grounds, albeit there's obviously an inbuilt element of that area of judgment within the language used. What this language is doing is recognising that you can't, and this is of course a directive that has to apply to a huge range of plans and programmes, not just things like MPSs or development plans, but a vast range of plans and programmes, policies across the European Union. And there's no sensible way in which that directive could ever have dictated, in a sort of hard legal-edged way, mandatory way, what must be looked at each time for those plans. And so the solution to that, in my submission, in 5.2, was to build in this area of judgment before decision making. They have to decide what's reasonably to be required.
I can well understand that there may be an area of judgment. I can well understand your submission that where there are technical or scientific matters, the court may well give more weight to the opinion of the primary decision maker. Where I'm having difficulty at the moment, at least speaking for myself, is accepting the submission that the legislation means that it's for the initial plan-making authority to decide what's reasonably required. In other areas of law, where concepts like whether something is reasonable are used, that's usually taken to mean that it's an objective question. So a police officer may arrest if there are reasonable grounds to suspect. That doesn't mean if the police officer thinks. That's Lewis and Anderson.
Well, in this context, in my submission, that approach just can't work because the nature of the items that are having to be considered by reference to the information that may need to be provided, the kind of issues that are themselves raised in 5.2, current knowledge and methods of assessment, the stage in the decision-making process relative to the DIA directive, those are matters that inherently must be for the decision-making experience. And in my submission, that's what that language is telegraphing. I'm not saying the court has no control, because obviously the court does have control through the Wednesbury text. But this is putting a judgment on the part of the authority, because it has to, because this directive can't lay down, a hard-edged legal way, the requirements for every AOS, for every type of plan and programme that this could apply to. The reach of this directive is very wide across all kinds of plans and programmes across Europe. One couldn't lay down a sensible way. And what of law, in my submission, is the court going to be well placed to exercise that judgment in the primary way, because one immediately gets into, on almost all of these, almost inevitably, a technical issue. Certainly when we're talking about, as we are on scene, noise, who's likely significantly affected by noise? Well, that itself involves a number of detailed technical judgments that are being exercised. And in my submission, the court is not going to be well placed to adjudicate on that other than through the Wednesbury test. And well, 391 is, I think, was the paragraph which my Lord Justice Singh drew attention to, and that's where the court brings this together, 391. And the court also looks at this briefly, just mentioned. 399, the court refers to the domestic legislation, which you'll see is in exactly the same terms. And then 400, you'll see the court says, plain from the language, as may reasonably required, that the SEA regulations, like the directive, allow the public to make a judgment on the nature of the information to be included. That's the correct division of 42 from my Lord, I say that's the correct approach.
You've gone past paragraph 397, which may contain the answer to my Lord's earlier question as to the endorsement of.
Well, yes, Cogent was certainly endorsed in their pastoral, but I think my Lord Justice Singh question was particularly about that passage on sequel.
Yes, that's what I wasn't quite
Yes.
sure.
And that's, I am going to come to that. We're
Yes,
going to briefly look at that.
I see, yes.
With that specific question. Then, well, in the notes, the next point is quality issues, and we'll keep the judgment open because, I mean, below the borough's submission was that the court should be exercising some form of quality review of the AOS. Now, that's not the submission that's been pursued before this court. Rather, my learned friend refers to those quality points as supporting his submission that there should be some kind of enhanced Wednesbury review. But my lords, if you look at what the court said on this quality point, the source of this quality point, 407 of the judgment, is Article 12.2 of the directive, which my learned friend took you to, and what was said by Mr. Justice Collins in Forest Heath. Now, I think it's saying Mr. Planning may have said there was some support in a Mr. Justice Ousley decision for this, but I'm not, at the moment, I'm not aware of that, but I'll focus on Forest Heath and Article 12.2. And what the court says is that if you look at Article 12, it is an article that is in an information reporting and review, and what it requires principally is for member states to provide information to the Commission about how it's ensuring that AOS is meeting certain quality. It's not an obligation that bites directly on the decision maker in terms of making the AOS. It's actually an obligation that lies on the member state to communicate with the Commission how it's ensuring quality. And well, that's how the court reasons that through in 407, 409, and 411 to 412, and indeed also 414. And whilst the court below saw nothing in Forest Heath that supported the view that that reference to quality as a reporting mechanism was something that should bite on the court. And what Mr. Fleming's submission was, to your lordships yesterday, that this bites on the court, because the court's part of the member state. But I don't think my learned friend is suggesting that your lordships have to report to the Commission in relation to the quality of the AOS, and that's the principal obligation that we're talking about here. Well, in my submission, Article 12 doesn't take my learned friend anywhere at all in terms of arguing for a higher standard of review. Well, I've then referred to Evans again. I won't go back to that. It's the same point that I made in the Habitats Directive about what the Court of Appeal held there about the standard of review on EIA being 23. I then referred to Mott, and I'm not going to go to it, my lord, but I've given you the key references in the judgment where the court below brings in Mott. And Mott's relevant, of course, where we're dealing with what are technical, evaluative, predictive scientific judgments. And in that context, of course, the Court of Appeal in Mott says there is obviously a larger margin of appreciation for decision.
It would help me at least to understand what you say the ratio, the basis for the decision is in Mott.
Well, I would take the lordship to those paragraphs in where the court deals within its judgment, if that is 176, because
Yes.
that pulls up in my submission the key things that derive from the case. So my lord, 1435,
I'm sorry.
yes, 1435, which is the judgment of the division.
Oh, sorry, yes. That cites the relevant passages.
My lord, yes, and there's several references to Mott. My lord, in my submission, 1435 in the division of course judgment is a pithy but entirely accurate summary, in my submission,
Right.
of the ratio. There are some other references I'll take in a moment, but where you have matters of scientific, technical, and predictive assessment, the courts afford an enhanced margin of appreciation to a decision maker on those matters. And then, my lord, the court picks that up, the court below picks that up in several other places. I think probably we can go to 176, and you'll see 176 reference to the correct approach in Mott, and then the court describes the facts of the case at 176, and then we'll see over at 177 the court has extracted the key passages from Lord Justice Peterson's judgment.
Yeah. Was it the judgment of the court? Well, it doesn't matter.
Someone can check.
That's not how I remember it, but perhaps I'm misremembering.
Someone can check that now. I'll come back to you. No, well, I don't think it is the judgment.
It was a judgment with which Lord Dyson, Master of the Rolls, simply agreed, I think.
Yes, I think that's correct. Following on tab.
Anyway, we can check
Okay,
that.
okay, well, the other.
There was only one judgment, a substantive judgment.
So, well, the next thing that leads to in the note is that the court below did raise what they said were practical and evidential issues. And I'll just refer you briefly to those 4 through 7 is where this starts. Well, it's 437, 438, and 439. And we'll summarise what's going on here. You'll see in 437, the Hillingdon claimants sought to advance their case on these issues in considerable detail. Large parts of extensive witness statements filed on behalf of them contain detailed criticisms of the AOS. And the Secretary of State responded in kind about 250 pages of witness statements. There followed further exchanges of witness statements and reply. But by this stage, the process had already become reminiscent of a planning inquiry. And well, that is, in my session, the danger that the court was identifying. Of if the court takes too intensive a review, if the court looks at itself directly at what is reasonably required, there is going to be a huge proliferation of evidence. And this case is a very poor example of it, because in order to respond to what were lengthy witness statements, making very detailed point-by-point criticisms of a 1,000-page in total appraisal of sustainability, we've ended up with 250 pages of witness statements in response. That's just witness statements, exhibits, etc. to those. And well, that's the danger of we're heading.
You say that this process, the new process, statutory process, shouldn't become a proxy for a planning inquiry.
Exactly. Well, that's exactly what it was intended. Actually,
Well,
exactly what it was intended not to do.
to those more deeply steeped in the history of these things than others, it might be said that is where we all came in. The background to the present statutory arrangements is that very lengthy public inquiries indeed were being held into major infrastructure projects, not merely runways.
No.
Though the paradigm example is, of course, the Terminal 5 inquiry.
It is not, and that's the white paper that led to 2008, which is referred to by the divisional court towards the beginning of the judgment, cites in particular T5 as the key justification for this new regime.
Yes, I mean those who are less enamoured, if you will, of the present arrangements would say it is therefore at least all the more important that the initial stage is rigorously and scrupulously sound in its treatment of
Yes.
these matters.
Well,
That we don't get into that broader debate, but that's the context in which the debate here takes place.
well, what it is, and I can't find the passage now, but the Divisional Court dealt with this below because one of the submissions that was made was that because planning inquiries have gone for these types of construction projects, that's a sort of removal of procedural protection, which should support the court being more intensive in its review. That was one submission.
Yeah.
The court said, well, that is one element of the statutory scheme.
Yeah.
The other element of the statutory scheme is that what that statute introduced was a statutory set of rules and procedures for the adoption of national planning policy. Because obviously, as your Lordship will appreciate, other than under this Act, planning policy, as decided by the government, has no statutory basis or control over the way it happens. And so you have a full set of consultation procedures, obviously the requirement for AOS, but also the requirement for parliamentary approval. And the court saw that, the court below saw that as a counterbalance in the statute to the removal of inquiries. The procedural protection is built in other ways. I'll try and find that.
Yes, if you had the reference, not necessarily straight away,
No, I'll find it in due
that
course.
would help us.
I haven't got it to hand.
We can find it, of course, but they did treat treat that point with some conclusions of their own.
Yes, and I'll find that for you in due course.
Thank you.
Mr. Ricci, I wanted to ask you about, before we leave this topic, I wanted to ask you about something different.
Yes.
I just wonder, speaking only for myself, whether there's sometimes a risk that we lawyers pose a dichotomy which is not necessarily one that has to be imposed. In contexts like the law of negligence, where the question whether somebody took reasonable care, that is undoubtedly an objective question for the court to decide. But that doesn't mean that if you've got, say, expert matters like medical judgment or something, that the court doesn't pay appropriate respect. And this is why we have the Boland test. So if there's a reasonable body of medical opinion that would have done that, then that will mean it's not negligent. But ultimately, the question remains an objective one. I just wonder whether it necessarily follows, just because the court has to decide whether something is reasonably required, would that lead to the conclusion that the court suddenly becomes the primary decision maker?
Well, it may not lead to that, but it certainly will, I fear, lead to a massive proliferation of evidence, competing evidence,
Yes, I see.
about what is the practice and not the practice, and whether this is something that you should do or shouldn't do, and whether others would do that. And that is some of the evidence we've got for this court. And the only point I make to what the Divisional Court is saying is really that's not where these type of challenges should be heading.
Yes, I see.
My Lords, can I then just, so I think I've done at 20. 21, of course, the court said, at least in relation to some of the complaints made by boroughs, this is academic, because they would have rejected their complaints about the defects in the AOS, even if they'd applied a higher standard of review to that. And then my Lord, one also has, there's one point, I don't think we need to go to this, it hasn't been emphasised at all in Mr. Planning's submissions, but we did record in our scale, and I give you the reference, that the boroughs themselves appear to have misunderstood in one regard what the court decided on the standard of review. Mr. Moe didn't push on the other submission, so I'm not going to go to it. But Mo, can we just turn then to Blewett and what the court below said about Blewett? So judgment 403. Judgment 403. There's a lengthy quotation from Blewett in 403. And well, as I just pick up at the very end, a very famous perhaps about 8 or 9 lines up, you'll see the regulations are not based upon such a unrealistic expectation, i.e. that the report will contain full information. They recognise the environmental statement, EIA, may well be deficient and make provision through the publicity and consultation process for any deficiencies to be identified, so that the resulting environmental information provides the local planning authority with as full a picture as possible. Well, that ties back, my lord, to paragraphs 2 and 3 of my note. It's the same statutory scheme for SEA. You don't assume the report's going to have everything in it, because that's why you allow for consultation publicity, so people can raise other environmental issues, and all of that can be considered as part of the assessment. And then, my lords, the last few lines, there will be cases where the document purported to be an environmental statement is so deficient that it could not reasonably be described as an environmental statement as defined by the regulations, but they are likely to be few and far between. So that's the classic statement, and I'll show you what the court made of that in a moment. And then 419, if you go forward to 419 judgment.
Has there ever been a case, actually, in which that has been held?
Well, my lords, the way the court...
I mean, Berkeley actually, well, I'm not sure Berkeley really is that case.
No, Berkeley wasn't that case because there was no environmental report at all.
That's right.
My lords, I'm just reminding there's a decision of your lordship in the last 6 months.
There is that.
Well, about the fact that there was an environmental report on an EIA where there had been an assumption that certain matters would be controlled by another regime,
Yes.
which was wrong. So therefore, the environmental assessment failed to consider a whole series of things.
Yes, no, that I remember that case.
And well, that's presumably an application, I can't recall whether it specifically deals with it, of the Blewett test. It's
Yes.
just a very clear failure to do something.
Well, it was something that fell between two processes.
And mistakenly so, because obviously it was not covered in the other
Yes.
regime. So well, that's one example, my lord. I'm not sure whether your lordship, I think your lordship's judgment may mention Blewett, but I can't recall that was particularly the focus of the analysis. But
I may have mentioned that. I can't remember.
well, my lords, and then if you look at 419, you'll see that's 6 lines down. It's just how the held. The starting point was that it was for the local planning authority to decide whether the information supplied by the applicant was sufficient to meet the definition of an environmental statement subject to control on Wandsworth principles. And then about 6 lines from the bottom, instead, deficiencies in the environmental information provided may lead the authority or deciding to refuse permission in the exercise of its judgment. Thus, the statement in 41 of Blewett that the deficiencies must be such the document could not reasonably be described as an environmental statement in accordance with the IA regulations was in line with Judge's earlier observations. It simply identified conventional Wandsworth grounds as the basis on which the court may intervene. And my lord, I fully support that view of that position of the court, that we don't read some separate test into those last few words about whether it's a document that's so deficient it could not reasonably be described. That is, the division of court said, simply an application of the Wednesbury test. And well, I'm perfectly content, very content with that formulation by the division of court. And then, my lords, if you look at the note 24, I don't ask you to take this up, but Edwards, which you've got in the authority bundle, is important because not only does it endorse Blewett at House of Lords level, but well, it wasn't actually endorsing Blewett in relation to EIA. Because although there was an EIA issue in Edwards, there was an argument that EIA applied to this consent process that the Environment Agency were undertaking. The House of Lords rejected that part. And so Blewett was actually applied to the consideration of a report under a different directive, the IPPC directive, which is the Integrated Prevention Pollution Control Directive. Now it is called the Industrial Emissions Directive. And so, well, that is Blewett approved by the House of Lords and not confined to EIA because it was applied beyond EIA in the Edwards case. And then, well, that takes us to the numerous High Court decisions which have applied Blewett to SEA. And well, I haven't got time to deal with all of them. Can I just show you Shadwell, which is volume 3? And well, it's the most important one. It's Mr. Justice Beatson. And well, the reason it's the most important is that all the others effectively follow the Shadwell approach. But the most extensive reasoning we have is Shadwell. So well, let's put volume 3, tab 47. And well, as you'll see, paragraph 1, it involves SEA because it was a case about a challenge to an action plan, which is a type of development plan. And you'll see at 8.1, the complaint was the council felt to have an adequate sustainability appraisal in breach of the SEA regulations. And then model 71, see there's a heading, the process and role of the court, which is introduced by the judge at 71. And then when I go to the page at 73, as to the role of the court, review the adequacy of environmental appraisals, assessments and impact statements. On conventional web ground, see Milne, Islington, Fair and Islington, and then Jones and Mansfield, and also Bowen West, which is, of course, called Peel, decision that I referred to yesterday. 74. What does review of environmental documents on conventional grounds mean in practice? The judgments of Mr. Justice Singh, Bedford, as he then was, and Blewett, and of Weatherup in Seaport illustrate the general approach of the court. And this is Mr. Justice Uzi distinguished deficiencies resulting from the omission of topic, or because it's been inadequately dealt with, which may have faults on planning merits, and deficiencies which show there's been an error of law, I mean the document cannot reasonably be regarded as an environmental statement, i.e. the Wednesbury. So then Blewett is cited in passages we've seen before. And then 78, in Seaport, Mr. Justice Weatherup stated the responsible authority must be afforded a substantial discretionary area of judgment in relation to compliance with the required information for environmental reports. He also said that the court will not examine the fine detail of the content of such a report, but will seek to establish whether there fits substantial compliance with the information required. He went on to consider whether the specified matters have been addressed, rather than considering the quality of the address. So a rejection of quality as being the hallmark of review, but also will not review the fine detail of the contents, and unfortunately that's very much what this case from the outset has been about. And it's a very clear application of the Blewett line of authority into SEA. This was the first case to do it. I'm going to put that away. That's the first case to do it, and that was followed Friends of the Earth, which is Mr. Justice Hickenbottom, he then was, Ashdown Forest, which is Mr. Justice Sales, the first instance was, and Gladman, and I've forgotten the rules talking about it, so I will check that for you. And then, of course, by the Division of Court below.
Sorry, Friends of the Earth, just give me the names again.
Well, Friends of the Earth, well, they're all in B, they're in my note.
Oh, they're in the note. Yes.
25B and C.
Sorry.
You've got all three.
Oh, yes, I know.
And then when I was having asked you to put away volume 3, I was going to show you no Dastrel, so you can get it out again. I'm sorry, 53. I'll deal with it briefly. We'll just, if you look at, you'll see at 48. Page 565, there's reference to cogent judgment of Mr. Justice Singh. Discussion of what the case was about, then some citation from what was said in that case. And then at 50, you'll see this. This, I think, is what, in my submission, answers the question that was put to me by my Lord Justice Singh. He, which is your Lordship, then considered a number of authorities, including decision of the Court of Northern Ireland in Seaport. Well, that's the passage that we're looking at where you cited Seaport, and some other cases. And then there's further quotation from your Lordship's judgment. And 52, you'll see finally Mr. Justice Singh drew an analogy with the common area of environmental impact assessments, quoting from Blewett. So effectively approving your Lordship's application of Blewett in that context. Well, the issue was slightly different, of course, in cogent. It was about whether you could cure defects by a supplementary document. But nonetheless, your Lordship, in the judgment, sought to apply the Blewett approach to SEA. And from what I can see from 53, Mr. Bucks in his submissions said he did not disagree with the analysis of cogent. That was a realistic start in my judgment. The conclusions reached by Mr. Justice Singh on the issue of principle is correct. Similar views expressed by certain Justice Sales in Ashdown Forest. Now, some of that may be about whether you can have subsequent documents curing defects, but in my submission, that also encompasses approval of the application of the blue approach to SDA, which is what I say your lordship did in cogent, albeit on a slightly different issue to what we've got.
So is it your submission that no ad astral being a decision of this court is therefore binding on us
Yes.
on this issue?
Well, I do make that submission. I made it below. The divisional court didn't accept that submission. They didn't actually, as far as I can recall in the judgment, they didn't expressly disagree, but they did not support my submission that they were bound by no astral. They saw no astral as more focused on the issue of the allowing in supplementary documents rather than being focused on this particular issue that I'm raising today. But my lord, I do maintain my submission that it is approval, but going beyond that for the application of the blue approach.
In Seaport,
Yes.
there was a reference,
There was.
and I forget now what happened in the end.
You mean when it came back?
Yes, it came back.
Exactly. So it never,
Yes.
there was never a further judgment. It was the developer. It was a developer challenge in relation to a scheme they wanted to get for housing, and I think they managed to achieve
Yes, well, I remember I was
Your lordship
I was an
involved?
advocate in Seaport, and I was trying to recall what had happened because the case did go to the Court of Appeal in Northern Ireland, presided over by the then Lord Chief Justice of Northern Ireland, now Lord Carr, and I remember it going on a reference, and then I think I may have moved on to another life.
Yes, my lord. Well, my lord, yes, I think because I acted for the UK government on the reference in that case, and I think I recall now it was your lordship and Mr. Gregory James who were acting for Seaport. Well, what happened was the challenge was withdrawn because some kind of something happened behind the scenes. So I can't recall the details.
So it doesn't take us any.
There was no further judgment. And then we'll see 27, the Divisional Court then looked at some challenges which had succeeded on SDA, St Albans and Hurd, and they're cases where effectively they've been a complete failure to consider alternatives. And then the Divisional Court draws all this together, my lord, 434, starting at 434, which is a paragraph that we fully support as setting out the correct principles. Where an authority fails to give any consideration to a matter which is explicitly required by the directive to address, such as whether there are reasonable alternatives to the proposed policy, the court may conclude there is due non-compliance with the directive. Otherwise, decisions on the inclusion or non-inclusion in the environmental report of information of a particular subject, or the nature or level of detail of that information, or the nature or extent of the analysis carried out, are matters of judgment of the planning authority. Where a legal challenge relates to issues of this kind, there's an analogy to judicial review of compliance with the maker's obligation to take reasonable steps to obtain information relevant to his decision, or of his omission to take into account consideration which is legally relevant, but one which is not required, e.g. by legislation, to take into account, and then citation of various cases including Creed NZ. And then the established principles of decision maker's judgment in such circumstances can only be challenged on the grounds of irrationality, more citation of authority, and then the bluest approach is simply an application of this public law principle. So that's the principles. Well, can I then turn to the local plans issue, see if I can make some progress on that before I hand over to Mr. Humphreys. Well, first of all,
The P&P issue you've gone for.
my lord, yes, the plans and programmes.
Plans and
Sorry.
programmes, sorry, yes.
Other relevant plans and programmes.
Yes, I know.
One of my own abbreviations in my
No,
own
that's
rather
the
than,
abbreviation is now clear to me.
So, well, the first thing I should say is Mr. Fleming, I think, spent about a minute on this issue in his oral submissions, but there is, of course, a case that's been advanced in writing in relation to this. And well, as I asked you just to, I've given you the key references to the judgment and our evidence dealing with this issue. The evidence is extensive in Ursula Stevenson's statement. It's over 80 paragraphs in her first witness statement and a whole of her second witness statement on this issue. The first thing is that the nature of this case has changed, as Paul pointed out, to 445, because originally, as pleaded, what was being said by Boroughs was that there was no identification of relevant plans and programmes in the form of local plans. And as the court said, that was a submission that was never going to go anywhere, because it was quite clear there had been express coverage of them. So the complaint has changed, and the complaint is really about whether we dealt with them adequately. Did we deal with them at the right level of detail? And there's a series of points which I've sort of drawn out by reference to Ms Stevenson's evidence. And I'm going to have to go through them quite briefly, but I hope to just give you a guide to the reading of that statement. So, first of all, paragraph 32, this is actually in her second witness statement, she makes the point about the relationship between an MPS and local plans. So the obligation, of course, and we see this in 31, the obligation is to consider in outline the relationship of your national policy statement with other relevant plans and programmes to the extent reasonably required. That's putting all the legal provisions together, that's what's required. An MPS is going to have a relationship with a huge number of plans and programmes because it's a national policy, even when it's site specific, it's a national policy. And so, well, as you have got in the bundle, I'll touch on it later, I'll just give you the reference. There's if you look at paragraph 40b, I've given you a reference to the AOS scoping report, Annex A to that. That's 175 pages of other plans and programmes that were considered in scoping. One entry of which I put under Lordship's suggested reading list was a short entry in relation to local plans. So they were on the agenda, but they were one of hundreds of plans and programmes, nationally, internationally, etc., that had to be looked at. And the point that Ms Stevenson makes in a second witness statement, which I don't ask you to go to now, because it's paragraph 32 of my note, is of course a national policy statement sits above local plans. So there are some plans and policies which a national policy would be below, so perhaps a European policy or programme, or at the same level as, i.e. other national planning policies. But local plans sit below national policies, and she refers, of course, to the relevant statutory provision in the 2004 Proposed Question Planning Act, which says that local plans must be compliant with national policy, or they must have regard to, and to be sound under the NPPF, they have to be compliant.
Yes, but they don't have a statutory presumption
They don't.
in their favour. That applies, am I right in saying this, that applies to national policy statements?
Well, it does in a slightly different way, because that's section 104. I mean, in a way it's stronger
Yes.
than 38.6, because it says you shall determine in accordance with the NPS, unless these subsections apply.
Yeah, so it's a parallel but
It's parallel,
but
possibly
stronger presumption, you say.
But well, the reason I make this point at 32 is just to say that in terms of the relationship between what we're concerned with here, because the complaint is about local plans, the national policy statement automatically would sit above those local plans, and in due course those local plans, when they are reviewed, will have to be brought into compliance with national policy, including the NPS. So just
Sorry, it would be paragraph 1.
yes, I think it should be paragraph 1.8. Sorry, correct. No, no, that's correct. That's
Sorry. Well, I've missed something.
paragraph 32 of my notes.
Should be paragraph 1.8. I'm sorry, yes. Thank you for that.
Then on scoping, there was a requirement, as I've said earlier, to scope the report with Environment Agency, Natural England, etc., those environmental statutory bodies. And Ms Stevenson's evidence records that there was discussion expressly about to what extent should local plans be looked at. That was one of the issues raised. And then, my lords, Ms Stevenson makes a point about what's feasible and proportionate. And can we just look at that very briefly? So, well, that's in bundle 6, page 271. Take two paragraphs. There's a whole section on this, but 340. It's acknowledged, for example, like the claimant suggests, that a number of plans, including the London Plan, London Environment Strategy, which includes a zero carbon target, were not covered individually in the AOS scoping process. It would have not been feasible for this work to be undertaken at the scoping stage. And then 344. If the AOS scoping or assessment process attract the effects of each local development plan policy and document individually, in addition to the 175 pages of international national PPPs set out in Appendix A to the scoping report, the exercise would not be proportionate, and as is explained below, would not alter the appraisal framework, and I'll come to that point in a moment. But well, in terms of what's reasonably required, when you've got a national planning policy, there's a scale issue. this was already a vast undertaking. If one has to track through, as I think it said we should, individual plan policies and documents. So my Lord or Justice Lindblom in particular will be aware of just how lengthy local plans are these days, hundreds of pages, hundreds of policies.
Yeah.
The idea of tracking through all of those, for every local authority area affected by a national planning policy, would be an intolerable and impossible burden.
That doesn't mean you shouldn't do it at all.
And
Does it?
correct, my Lord, and we did do it, my Lord, but we looked at local plans and their policies cumulatively. That's what the court below found, and I'll show you the references. We didn't do it on an individual basis, we did it cumulatively. And we say that's a reasonable response to the requirement, given the scale of the task that's been and then when I was just going to my note, you'll see 35 similar points that Stephen make about the national scale of an MPS and how difficult it is if you were going to track through every individual policy individually. And then 36, this is important. If you had looked at local plans individually, it would have made no difference. And well, that's recorded in the court's judgment. Just briefly look at what the court said on that. 455. You'll see the judges there refer to my submission that the approach that was taken to look at it cumulatively followed what had been done on other MPSs, nuclear energy MPS in particular, explained it would not have been appropriate to analyse fully, and that even if you had followed that approach, the appraisal framework would not have changed. And the significance of that is if you probably just looking at 453, top of the page, there's a quotation on top of the page, and there's some text from the court. Thus, although individual effects on local authority areas were not separately identified, the cumulative effects of such factors as additional demand for housing, community facilities, together with impacts on open spaces, were weighed in the balance, and they were assessed as counting more severely against the Heathrow schemes than the Barrett. So we looked at it cumulatively, the kind of issues that local plans throw up, housing need, community facilities, open spaces, were taken into account, but not tracked on an individual basis through local plans. And that's what the court found was acceptable. And my lords, if you then look at my note 38, the purpose of looking at other plans, programmes and plans, if you go to Miss Stevenson's witness statement again, Article 6, paragraph 3.25, she says the SEA practice which we guide in the UK is to incorporating the relationship of other plans and programmes in addition to other environmental protection objectives. So that's step one, is to ensure that these inform the development of an appraisal framework made up of objectives against which a plan and its alternatives are assessed. So the reason you look at all these plans and programmes is in order to develop your objectives and your appraisal framework. And that's exactly what happened here. And the appraisal framework included impacts on community, housing, open space, those kind of matters.
Sorry, the paragraph reference was 3.
Well, 3.25.
25, yes.
On page 268.
Thank you.
And she then quotes, I think, some guidance on that. And then, well, as I made the submission, I'm going to bring this to an end. I made the submission that what we did very closely tracked what happened at Hinkley on the nuclear MPS and the practice that was followed there. And then, as I've given you some references, paragraph 40, the judgment below records this very neatly in a handful of paragraphs. I've tracked through some of the more detailed references of the express consideration given to local plans, but on a cumulative basis. So local plans are referenced in the scoping report, the appendix A to the scoping report, in the main AOS, but not on an individual basis. They are, all the plans are listed, all the authority areas are listed, but they're done on a cumulative basis. And that leads the court, my lord, judges to 457 and 458. And my lords, what they refer to there is that I handed in below a table of key points where you can track through the AOS references to the kind of issues that local plans would have given rise to: housing, schools, community facilities, increased demand, development facilities, etc. And I tracked that through in a note which is dealt with by the court below at 457 and 458. That note, my lords, we submitted it updated with references to the appeal bundle alongside our skeleton argument. Now, my lords, I don't know, I hope we've got spare copies if you haven't got them. But my lords, I don't invite your lordship to engage in the detail of it, but what it does is it allows you to track in considerable detail with all the references to issues like community impact, housing impact. If you haven't got a copy,
I don't have it in front of me, certainly.
I don't think it, I think, is the updated version brought in? I don't think it has. It wasn't in mine, but the name of mine hasn't been updated. Well, I was going to check if it's already in the, it's already been sent. It is in the main bundle, but it was originally in the form that went to the High Court. So, it's volume 9, tab 6.
9-6.
2199, so it's not. I was checking whether it's the old version.
Yeah. We do have that.
That's 2199.
You brought it up to date with references, had you?
No, well, I need to give you one that's got, I've got one here, I'll hand it out now. It came with our, should have come here. I think it then led to the boroughs updating their responding notes.
Thank you.
And you'll see, I'm not going to go through detail, but you'll see, for example, in the table, housing, that's one issue, and then a whole series of references to where that issue is dealt with. First of all, in the AOS, and then in the main report, the appendix on community, the appendix on quality of life. Similarly, open space, which is another issue that was raised as being something that those plans threw up. And then over the page, education, impact on schools, community facilities. So we track through, and that's what the court's referring to. And really the only point I make is that, yes, we looked at local plans cumulatively, but the issues that arise from these plans were very carefully and extensively considered throughout the whole process.
I'm going to put that in at tab 6 in volume 9, so we can all find it there.
And then, well, I think that just leaves me, I'm going to hand over to Mr. Humphreys now, but we'll just Paragraph 43, the overall conclusions of the court, I don't read them now, on 460 to 63, and we say the court was right for the reasons it gave to reject its plans and programmes point. My lord, there is a separate issue about the London environmental strategy, London carbon budgets, that's paragraph 45. Two answers to that. One is Ms Stevenson says again, and I think I've already showed you this in one place, but she says it at 3.52 as well. It wouldn't have made any difference to the objectives. The objectives that were set was to reduce carbon, to minimise carbon impact. If the LES had been specifically individually referenced, it wouldn't have changed the objectives in the appraisal programme. But more importantly perhaps, Ms Lowe in her annex to her witness statement says this point was directly raised with the department in the consultation responses and taken into account. And remember, environmental assessment is not just what's in the report, but the responses as well. So I'm going to hand over at that kind of noise to deal with. I'm going to hand over to Mr. Humphreys.
Thank you. Yes, Mr. Humphreys.
My lords, may I just say first, thank you to both the court, Mr. Marici, and indeed others for allowing me to be interposed in this way. I'm extremely grateful. My lords, there are four areas I'm going to touch on in these submissions. The first two relate to the HEA grounds. First of them is the concept of alternatives in the SEA HRA directive. Secondly, still under that overall HRA group of grounds in the claimant's submissions, hub objective. Thirdly, in the SEA grounds, the noise issue, and then fourthly, very briefly, I'll say a few things about relief. So in relation to the alternatives point, we say that the key paragraph on this distinction in the Divisional Court's judgment was paragraph 322. I won't take you to that now. I will be taking you to it, but to slightly save on time, I won't do so now. So 322, that's page 546, is absolutely key paragraph, and it draws the distinction between the use of the expression reasonable alternative in the procedural sense in the SEA directive and the use of the expression alternative solutions in the substantive context of the Habitats Directive. And, my Lord, I don't think that the distinction between these two, that one is procedural and one is substantive, is controversial. And again, I'll give you the reference to it, but not take you to it. In a Hillingdon position statement before the Divisional Court, which you have at Supplementary Bundle 9, tab 5, at page 2167, draw attention, for example, to paragraph 6 in that document. This was a note on Article 6.4. The Hillingdon itself draws this very distinction. So I don't think that is controversial. And, my lords, we say that there is no different meaning to the word alternative in the two different directives. They are simply being used in a different context. And my Lord, Lord Justice Singh, I think raised this point yesterday about whether or not context was important. In my submission, it's extremely important here, and I'm going to briefly go through the two directives and the use of the words so that that distinction of the way they're being used can be perhaps drawn out. So could I invite you first to look at the first authorities bundle and the SEA directive, which is on tab 7. My Lord, I know you've looked at this many times. I'm not going to read it out, but it's useful to have it in front of you. I'm looking at Article 5.1, and it's very clear there that the environmental report that has to be prepared has to, amongst other things, identify, describe, and evaluate the various different reasonable alternatives. And it's clear from that language, identify, describe, and evaluate, that there is a process going on. That process we know by reference to Article 6, which involves consultation. And in my submission, it's clear that to identify and describe and evaluate alternatives in an environmental report that is to be consulted upon, the report will clearly have to identify, describe, and evaluate some alternatives that may not ultimately survive the selection process against the promoter's objective. And it goes to the very point. In other words, there will come a point during the process where they are, or they may be, ruled out. And I use that expression. I'm going to take you to one of the judgments later where that expression is used. But it's clear that this is a process where various alternatives are identified, but the judgment is not made at that point as to what happens to them. And my Lord Justice Lindblom made the point that obviously SEA is a process involved with providing information to improve decision making, and that's absolutely correct. And this morning
my friend Mr. Marici read to you from a page. It was document at 9, bundle 9. Again, I won't take you to it. tab 3, 1710. That makes exactly that point. It wasn't the purpose of the SEA to actually make the decisions. Now, at that point, just to see what the divisional court did with this in paragraph 322, I would like you now just to turn to that. And that paragraph is obviously in bundle 1, tab 5, but page 546.
The paragraph.
Paragraph 322.
Thank you.
And the paragraph starts by talking about the fundamental differences. The first half of the paragraph, above line 10, deals with HRA. The second part of the paragraph, from line 10 onwards, the line where the sentence by contrast starts, is about SEA. So I'm going to go to the SEA part at the moment. By contrast, the requirements of the SEA directive for the content of an environmental report and the assessment process which follows are entirely procedural in nature. Thus, the requirement addresses reasonable alternatives in the environmental report is intended to facilitate consultation. The operator of Gatwick and other parties preferring expansion at that location would be expected to advance representations as to why the hub objective should have less weight than attributed to it by the Secretary of State, or that contrary to the provisional view, the Gatwick could satisfy the objective. And the outputs from that exercise, i.e. the SEA exercise, are simply taken into account in the final decision making on the adoption of the plan. But the SEA directive does not mandate that those outputs determine the outcome of the process. So the SEA is clearly part of the process of providing information, has to be taken into account, but it doesn't purport to mandate the outcome of the process. We say that that is correct. Now, let's look by contrast at the Habitats Directive. So we're back in the authorities bundle number 1, now at tab 6. I'm looking at Article 5. Sorry, Article 6. And the Article 6.3 is clearly the article, again, you're very familiar with it, I won't read it, about appropriate assessment. Article 6.4 is the one particularly engaged here. But the language and the construction is actually interesting and, I suggest, informative. It says, if, comma, in spite of a negative assessment of the implications for the site, i.e. a negative assessment under Article 6.3, and in the absence of alternative solutions, comma, a plan or project must nevertheless be carried out for reasons of overriding public interest, including those of a social or economic nature, member state, operative word, shall take all compensatory measures necessary to ensure the overall coherence of the Natura 2000 is protected and inform the Commission. So, you can see therefore from the construct there that in Article 6.4 that the absence of alternative, the negative assessment and the absence of alternatives is, may I put it like this, context, or they are preconditions to an argument that the plan or project must be undertaken for IROPI and then compensation secured. In other words, at the point at which Article 6.4 is being engaged, the process of looking at alternatives and coming to a decision that there is an absence of alternative solutions is a process that has been undertaken. Now, let's look at this in the Portugal case, which is Authorities Bundle tab 26, sorry, bundle 2 of the authorities bundle is tab 26. And I'd like to invite the court's attention to paragraph 43. We have looked at this before, but the emphasis and the way in which we were looking at it is rather different from the way I'll invite the court to look at it. Article 43 is talking about the absence of alternatives. It says the absence of alternatives cannot be ascertained when only a few alternatives have been examined, but only after all the alternatives have been ruled out. In other words, the absence of alternatives in Article 6.4 doesn't mean that there weren't ever any alternatives considered. The absence of alternatives is the result of the process of ruling out those alternatives. And so I invite the court to consider shortly, that's clearly in this case what the Secretary of State did. The Secretary of State had 3 alternatives before him as part of the SEA process. We can look at that. He went through a process which is written up in the Air Force National Policy Statement, in which he ruled out certain of the alternatives, thus leaving an absence.
I'm sorry to interrupt you, Mr. Humphreys, but may it be that one does need always to keep in mind the precise words of the directive? It doesn't actually say absence of alternatives, with due respect to the Advocate General. It's talking about absence of alternative solutions.
My Lord,
So does the burden fall on the word solutions, perhaps?
I'm not sure myself that solutions necessarily adds much here. I'm always conscious that all of these directives are translations, and
Yes.
I understand it that several of the translations
Of
can have
course.
slightly different meanings. Certainly in the Advocate General's opinion at paragraph 43 and in other places, she refers to just alternatives.
I see.
I don't understand a particular point to be being made by.
But the fundamental point I think you're making is that you have to bear in mind the different contexts
Yes.
and purposes
Yes.
of the 2 directives. That one is a procedural requirement,
Yes.
and obviously, as you're going through the exercise of thinking about things,
Yes.
then of course you're going to keep the options open.
My Lord, that's exactly
Whereas
my point.
Article 6.4 you submit is what's the conclusion you've come to as
That's
a matter
exactly
of
my
of substance. If the conclusion you come to after that proper process is B is not in fact an alternative solution to A, well, that's the end of it.
Yes, my Lord. And it's in that context that I submit Article 6.4 when it's talking about absence of alternative solutions, when understood in the light of the Advocate General of paragraph 43, the absence is because the alternatives have been, her words, ruled out.
Yes, I understand.
Now, my Lord, it seems to me, going back to the Divisional Court judgment, that the Divisional Court got this absolutely right. I go back to paragraph 322 of the Divisional Court judgment, 546. Page 546 is paragraph 322.
Just give us the paragraph numbers, we've got them separately. So,
322. And now I'll invite you to look at the way the Divisional Court looked at it in the first half of that paragraph, where it was looking at HRA. So after the opening sentence, it says, where a proposal whether to adopt a policy or grant consent for a project adversely affects the integrity of the European site, the operation of Article 6.3 and 6.4 of the Habitats Directive, and that gives the equivalent regulation numbers, determines the outcome of the process according to the results of applying the tests laid down in those provisions. It's therefore rightly said, Mr. Jaffe, these provisions are substantive in nature and not procedural. In our judgment, an option which does not meet a core objective of the policy should not be allowed to affect the application of Article 6.4. And then he turns to SEA. My lord, that I was going to say that entirely fits my analysis. I should be more humble. My analysis, I hope, entirely fits the way there the divisional court has put it, and therefore, in my respectful submission, my lord, this apparent confusion, the point about alternatives in some way being dealt with differently as to whether they're reasonable alternatives in the SEA directive or alternative solutions in the HRA directives is a distinction without any meaning. It doesn't exist. It's simply that the two expressions are being used at different times, different points in the temporal process. One's gathering information so that a decision maker can be informed. The other is talking about the outcome of some ruling out of alternatives and what happens in that the absence of the alternative solutions.
Can I just ask you to return to the sentence that you emphasised in the middle of paragraph 322? In our judgment, an option which does not meet a core objective of the policy should not be allowed to affect the application of Article 6.4, is the way they put it. Does that mean an option which does not meet a core objective of a policy does not engage the operation of Article 6.4?
My lord, I think what that is saying in effect is if you have ruled out the particular alternative as not meeting the objective, then it doesn't at that point come back into the process in some way. I understand that to be what they are saying at that point.
Yes, maybe I'm not seeing what's staring me in the face, but just wonder whether there might have been it's not a criticism at all, but I wonder whether there might have been a slightly simpler way of putting it.
My lord,
Well, what do you, of course, these are the court's words, not yours, but
exactly.
Is my formulation what you're submitting?
My lord, could I ask you to give me
An option which does not meet a core objective of a policy does not engage the operation of Article 6.4.
My lord, I think that would have the effect that I'm putting forward in my analysis of Article 6, and as I've read it in the light of paragraph 43 of the Advocate General's opinion.
Because X hypothesized no longer an alternative.
It's no longer an alternative. That's why there's an absence of alternatives. Now, in that context, my lord, and applying that analysis, which I say is correct, I'm going to go to the second of my points, which is to look at the Secretary of State's treatment of the hub objective. And I'm going to start. My lord, I think you can certainly put away the judgment for the moment. And you can put away the directives. We are going to need to come to, and you can put away the Portugal case, we are going to need to come to volumes 7 and 5 in a few minutes, and I'm going to start with volume 7. And I just want to start, and again, I will try and take this quickly. In volume 7, tab 2, if we could turn please to page 529. 529. Which is just after tab. That's the appraisal of sustainability, and your lordships were taken by Mr. Jaffe to section 5 of the appraisal, which starts on page 573. And section 5, starting on page 573, is about the development of alternatives for the purposes of the appraisal. And 5.2 you can see is defining reasonable alternatives. And Mr. Jaffe took you through some parts of section 5 to look at things like the first sift and the second sift and strategic objectives and so on. The simple point I'm going to invite you to note, but I'm not going to go all the way through it, is that what sections 5.3, which starts on page 574, and through to the end of 5.5, well, in fact probably 5.6 as well, is doing is it's reporting the Airports Commission's work on alternatives. So you can see at 5.3, 5.3.1 as an example, the Airport Commission interim report describes the approach. And if you go through each of these pages and you look at each of the tables and the initial sift and the second sift and the final sift, the shortlist, this is all the Airport Commission's work at this point, and therefore they're reporting by way of context to explain the reasonable alternatives that they came to, the work of the Airports Commission. They're not, in this document, as you would expect, coming to their own conclusions here. They're not ruling anything out, they're scoping the reasonable alternatives. Now, in that context, let's just see the way in which the Airport's National Policy Statement deals with this. So, I haven't taken your lordships to a whole lot of references there. You can look at them. Time is obviously somewhat limited, but I would like now to go to Bundle 5, tab 14, the Airport's National Policy Statement. And I'm going to take your lordships to various parts of section 2 and section 3, because these are the critical ones for what the Secretary of State did. So section 2, which starts on page 2432, so bundle 5, tab 14, 2432, is the section of the ANTS that sets out the need case, and it also obviously looks at and describes the hub objective. And again, your lordships have been taken to a number of these paragraphs, and so I'm going to try not to be tiresome about it. I'll identify some of them and just sort of very broadly, quickly say what they relate to. So on page 2433, there's a subheading, the need for new airport capacity, and we have paragraph 2.10 talks about challenges to the UK aviation sector and ends by talking about erosion of the UK's hub status relative to foreign competitors and constraining the scope of the sector to deliver wider benefits. We go on in the next paragraph, the UK now faces a significant capacity challenge. It goes on to 2.13, for example, the UK's hub status, stemming from convenience and a variety of direct connections, is already being challenged by restricted connectivity. My Lord Justice Haddon-Cave asked about the concept of hub and spoke, and you'll see there at the end of that sentence I read at the beginning of 2.13, there's a footnote 42, and that says, for more analysis on UK hub status, see the Airport Commission interim report, pages 90 to 92. That's a document that we put in this morning, so it should have been inserted. So those pages, that exact reference, should have been inserted in Supplementary Bundle 8, tab 3, starting at page 1110.1. I don't know if it's found its way into bundles yet, but it...
In any event, I have to say, speaking for myself, Mr. Humphreys, I would be very unhappy if anyone, other than my clerk, was to start inserting things into my papers.
My Lord, I understand that. I don't think anyone else will have inserted them. I just don't know that they've been handed up. I just don't know whether your clerk has inserted them all.
Were they sent by email to our clerks?
They were sent by email, but I think paper copies were handed in this morning.
Or were they?
My Lords, I don't need, for this purpose, to take you in detail, but I invite you to look at this. It arose in the context of the questions yesterday about hubs and the importance of hubs and what hubs did, and there's some paragraphs.
That I do have on my bench.
Yes,
It's not been inserted, but you're quite right, it is here, yes.
Let me see if I can find it.
It looks like that.
Ah, yes, I did have that. Now I have to find it again, which I've done.
So this is the, so in the AMPS footnote 42, it refers to these pages as giving greater explanation of hub status and the importance of hub status. And again, I'm not going to read through it all, but let me just highlight one or two things. The relevant part starts on page 1110.2, it's paragraph 3.88. It says, for example, the strength of Heathrow's route network is underpinned by the transfer passengers. Many of the airport's routes to emerging markets and smaller North American cities would be unlikely to be viable without transfer traffic.
Just pause for a second, Mr. Humphreys. My Lord Justice Haddon-Cave does not have this.
I do.
Have we got a spare copy?
I do now.
It's emerged.
Good, thank you.
I'll just pause for a moment.
So paragraph 388.
Yes, and through to 394. But it explains the importance of hubs. It makes the point, first of all, that many routes just wouldn't be viable without transfer traffic. 392, for example, makes the point that transfer passengers tend to be highly price sensitive. In other words, if you want to fly from Madrid to a new emerging city in China, it probably doesn't matter much to you whether you transfer through Heathrow or Schiphol or Istanbul, and therefore as soon as an airport such as Heathrow becomes capacity constrained, it has a very direct effect. And you can see the point they make at 3.39. Although Heathrow has broadly maintained the proportion of transfer passengers,
339.
Sorry, I have slight number dyslexia.
That's right. 393.
Yes.
Yes, sorry.
It's never been a problem other than when I was a safety officer in Royal Artillery. Then it worked.
I'll try not to think
393.
about that.
The people around Salisbury Plain were always very safe, I can assure you. So it's making the point about Heathrow's maintained its proportion, but halfway through the paragraph it says the Commission's forecast suggests that if capacity constraints at the airport are not alleviated, the number of transfer passengers at the airport will first stagnate and then decline. This sees the transfer passengers drop from 22.6 million in 2011 to less than 4 million in 2050, and the number of destinations served from the airport fall by roughly 20% over the same period. So this is the danger, if I may put it like that, that the UK hub status faces if its hub is not able to grow. And one of the conclusions we know of the government's work was that Gatwick did not alleviate that. Going back to the
Just on this was part of an interim report
Yes.
into the general question of UK airports sector.
Yes, the Airports Commission produced a final report, but there was an interim report on which there was a lot of consultation and further work. The reason I produced that is because it is that, the pages from the interim report, that the airport's national policy statement refers to. It's that footnote 42, and so it's not entirely capricious that I've just chosen this. It's because the AMPS refers us to that. So I was in the AMPS and I was just drawing your lordship's attention to footnote 42, paragraphs 214 and 216 are making many of the same points about the consequences of not increasing capacity and hub capacity. Don't need to read those. But if I do go to para 2.33, right at the end of that section of the AMPS, page 2437, you can see that the AMPS here says the next chapter sets out how the government has identified the most effective and appropriate way to address the need for increased airport capacity and maintain the UK's hub status while meeting air quality and carbon obligations. And then in section 3, what you see in the early paragraphs in section 3, 3.2, 3.4 and 3.9 to 10, the government here tell us that they clearly start with the Airport Commission's work, but they then commissioned an awful lot of additional work and carried out their own analysis. And what then follows from paragraph 316 is the results of the government's analysis of both the Airport Commission work and its own work. And we've had in this an awful lot of focus on paragraph 318 and 319 about 319 says the expansion at Gatwick Airport would not enhance and would consequently threaten the UK's global aviation hub status. We're taken toward that. What we haven't been taken to, and I think might be useful to take you to, is the overall conclusions from section 3. Because it's in the overall conclusions that the government pulls together its analysis from all the previous sections. And this is on page 2451. So paragraph 3.71, again I'll summarise, explains that this whole section, section 3, is summarising the factors that the government considered when evaluating each of the 3 schemes that were shortlisted by the Airport Commission. Towards the end of that paragraph, 371, it makes it clear that they brought these considerations together and the government's decision on a preferred scheme balances a range of factors which enable it to determine overall which is the most effective and appropriate means. 372 talks about the appraisal of sustainability. Again, your lordships can read that, but the crucial paragraph is 3.73. The government say there, building on this assessment, the government has identified a number of attributes in the manner of strategic effects which it believes only, I emphasise the word only the preferred scheme is likely to deliver to meet the overall needs case for increased capacity in the southeast of England and to maintain the UK's hub status. The government has accorded particular weight to, and then it gives 4 items which all arise from the previous text. Now, going back to my analysis of Article 6.4, my point about under the SEA directive you look at a number of different reasonable alternatives because you want to gather information, but the HRA directive you look at, you rule out things in order ultimately to arrive at an absence of alternative solutions. That's exactly what is happening in paragraph 3.73. The government has taken everything into account, both the Airport Commission's work and its own analysis that precedes these paragraphs, and it has come to the conclusion that this is it's only the preferred scheme that meets the objective. Now, that judgment is not challenged. There's no challenge to that. It's not said, nor could it probably be, that that is in some way irrational. The government couldn't come to that proper conclusion. The challenge is that in some way reasonable alternatives is being dealt with in a different way to alternative solutions. And I've dealt with that point. Once you take the point, as I say, is correct, that the absence of alternative solutions is the result of a ruling out exercise, that's what the government is doing in section 3 of the ANPS. And therefore, in my submission, the government's position on this is entirely robust, and there is nothing at all in the challenge. Now, turn quickly to my third heading, which was under the SEA grounds and noise. And here, Hillingdon allege a number of flaws in the appraisal of sustainability relating to noise, and in effect those are that the government has in some way not looked at the right area, or not characterised the areas of likely significant effects. And one of the principal themes in that is this difference between 54 dB and 51 dB LAQ16 hour as the Lowell. And in my respect for the submission, Hal's submissions on this are simply misconceived. What Hal appears to allege on this is that the government took 54 dBA as being the Lowell, and that's clearly not the case. And for that proposition that that's what they're alleging, I just point you to their skeleton. I'll give you the reference. It's Core Bundle 1, Tab 2, page 121, and then paragraph 81. And in 2 occasions in that one paragraph, they make this point that, well, the Lowell in some way represents my shorthand, the extent of significant effects. Please invite you later to look at where they actually put it. But in my respectful submission, this is to confuse 2 things. Likely significant effects, which is a concept, an EIA concept, which is usually to do with some change. You know, development comes into effect, that causes a change. Is that change a likely significant effect? On the one hand, and the thresholds that exist in the noise policy statement for England, Lowell, Seoul, and so on, which are different are intended to indicate a response type. And if we just look at that for a moment, I'd invite you to look at bundle 8, tab 3. Page 1087. So 1087 in the bundle is the 2010 document, the noise policy statement for England. This is not an airport exclusive document. This is a general government policy on noise. It's a DEFRA document. And sets out a number of things. At paragraph 1.7, for example, on page 1090, you can see the long-term vision, sets out the aims of government policy: avoid, mitigate, and where possible contribute to improvement of health. And those are important when considering Lowell's and Souls. So Lowell's and Souls are introduced on page 1094. Just over halfway down is the heading, what the aims of noise policy statement in England mean. And it talks about, it says 219, there are several key phrases within the MPSC aims, and these are discussed below: significant, adverse, and adverse. These are two established concepts from toxicology that are currently being applied to noise impacts, for example, by the World Health Organization. They are NOAL, no observed effect level, then Lowell. Lowell is the lowest observed adverse effect level. This is the level above which adverse effects on health and quality of life can be detected. Expanding these concepts for the purposes of this NPSE leads to the concept of significant observed adverse effect level. So it's not just Lowell, there's Soul. And that's the significant observed adverse effect. This is the level above which significant adverse effects on health and quality of life occur. And then a little further down, there's a subheading which talks about the aims. The first aim of noise policy statement: avoid significant adverse impacts. So above Soul, you avoid impacts. So in air noise terms, that would be noise insulation and things like that. First aim says significant effects on health and quality of life should be avoided, while also taking account of the guiding principles of sustainable development. And that's all about also achieving a sustainable economy. The second aim of the noise policy statement: mitigate and minimise adverse effects on health and quality of life. The second aim of the MPSC refers to the situation where the impact lies somewhere between Lowell and Soul. So between Lowell and Soul, the policy objective is to mitigate and minimise. And in an air noise context, that might involve things like night noise bans, alternation of runway usage, glide paths towards the airport, encouraging quieter aircraft. Those are the mitigate and minimise. Now, you can see that those are absolute thresholds. We'll come to it in a moment, but those are, there's no threshold set in the MPSC, it's set elsewhere, but you can see that they are thresholds, whereas likely significant effects typically, not always, but typically involves a difference. The new development has come along, what effect does it have? Does it make things worse? Now, government or at least the government's consultants in the AOS completely understood all of this. And so if we look at the AOS technical appendix on noise, that's volume 7, tab 2. 7, tab 2. We went to appraisal and sustainability earlier. It starts on page 529, but I'm going to take you to the part on noise, which starts further in. So in the bundle, same bundle, it starts on page 767. particular to the passages on page 772, 773, 774, and indeed 3 to 5. But 4.5 on page 772 is the assessment criteria. You can see here now how government have correctly understood the context. 543, they are quoting the NPSC which we were looking at. 454, they correctly identify the concepts Noel, Lowell and Sold, and in the next paragraph they tell us that the planning practice guidance has in fact created a further category called unacceptable adverse effect level. This is the level where the policy responses prevent. So this would be the sort of noise levels you would get right at the end of a runway where you would, if necessary, compulsorily acquire houses to move people. That's the policy response. The table 4.2 you can see is quoting from the aviation policy framework, and correctly, first row here is talking about the 54 dB criterion. That's based on sonar study. This is, you can see the footnote, the survey of noise attitudes. You do have that if you want to look at it. I'll give you the references. Supplementary bundle 8, 3, 1607. But the sonar study came up with a level of 54 dB, which signifies the level at which significant community annoyance starts to occur. It used to be 54, it's now, it used to be 57, it's now 54. And you can see over the page, they tell us right at the top, 54 is the level at which recent UK government sonar shows significant community annoyance starts to occur. This level can be taken, therefore, as within the observed adverse effects range. They do not say that 54 is low. Later down they'd say it very clearly isn't. What they're saying is we've chosen the 54, which is the onset of significant community annoyance, because it is in the range of Lowell, 51, to Seoul, which is 63. They have correctly identified that, completely contrary to the Hillingdon case on this. The next little arrow there, 63, tells us that 63 is the Seoul level. 459 tells us that identifying a Lowell for aviation is not straightforward. This is an area of ongoing research and debate. For the purposes of the appraisal of sustainability, local population exposure to airspace noise has been assessed against a lower bound set by 54 dB contour. For practical reasons, it becomes more difficult to estimate noise exposure accurately, and therefore population numbers affected below this level. This is because it's difficult to measure aircraft noise levels at greater distances from airports, where airport noise levels are closer to those of other noise sources. In other words, the lower the noise sources you get to, you actually get to kind of background levels, and therefore, yes, whilst theoretically you can keep moving your contours out, your contours become so low that ordinary road traffic noise, so I think the Welsh technical advice note on noise tells us that the human voice at a metre is 60 dB. Now, once you're getting down to these very low levels of noise in urban areas, you're simply not noticing this. Then towards the bottom of that paragraph, about 6 or 7 lines up from the bottom, the selected threshold levels are not identified here as aviation noise levels, but are adequate to enable the strategic appraisal to be conducted. In other words, government didn't say 54 was the low, i.e. the lowest level at which you could get any observed adverse effect. What it was saying was that for the purposes of this assessment, this is an appropriate level, and it is within that range. It's the level at which you start to get the onset of significant community annoyance. And, my lords, you will remember in Article 5.2 of the SEA directive, covered by Mr. Paricci this morning, those points about undertaking the assessment in the environmental report having regard to current knowledge and what can be known and what may come at later stages in the process. So, my lord, the submission that the government has erred in using 54 contour is just entirely inappropriate. There's a second limb to this where Hillingdon then say, well, but Heathrow Airport looked at a 51 contour. Yes, Heathrow Airport in its material has, quite rightly, looked at a 51 contour. And I invite you just to look now in bundle 9. We're just going to look at the air navigation guidance. That's tab 9, bundle 9, tab 3, page 1713. And my lords, again, I probably haven't got the time to read all the relevant paragraphs here, but on page 1718, there is the text on altitude-based priorities. This is where the 4,000 and 7,000 feet criteria come from. And you'll see in paragraph 3.3 that government has set different policy objectives for the CAA when designing airspace depending on altitude. And so from ground 4,000 feet, the environmental priority is to limit and where possible reduce total noise, effectively design airspace with that in mind. And then different spaces the higher up you get, the more important it becomes to have more direct routes, thereby reducing carbon dioxide emissions. And that's because noise becomes less relevant at those higher levels. 3.5 is talking about the Lowell, and this is what sets the Lowell at the 51, and it says 3-4 lines from the bottom. For the purposes of assessing and comparing the noise impact of airspace changes, the government has set a Lowell of 51 dB, LAQ for daytime, and 45 dB for nighttime, and the CAA should ensure that these matrices are considered. So the 51 dB Lowell is set for the purposes of considering airspace changes. Over the page, I just draw attention to, for example, 37 and 39. Below 4,000 feet, strong likelihood that aircraft would be creating exposure at Lowell, and 3.9. At and above 4,000 feet, aircraft are unlikely to result in noise exposure above 51. Where such exposure does occur, should ensure focus remains on minimising these impacts. However, at or above 4,000, below 4,000, the government expects the CAA to follow the altitude criteria. So that's the context for why Heathrow, in those various codes, and I'll just give you the references, but if you look at the Heathrow material we were taken to, the first is the Heathrow expansion stage 1A define assessment brief document, which was supplementary bundle 9, tab 3, page 2008.1 and following. It's very clear there that that document is talking about not just DCO consultation, but also ACP, airspace change consultation. That is why that document looks at a Lowell, because the air navigation guidance tells it to, and why it's also looking at airspace out to 7,000 feet, because at 7,000 feet and up to 7,000 feet, one is looking to create airspace to minimise CO2 emissions.
And those are the altitude-based priorities.
Those are the
referred to.
altitude-based priorities, and that's why
Paragraph
in those
3.1.
documents, the second document, Heathrow airspace design envelopes, that's the January 19 document. The reference is supplementary bundle 9.3, page 2093. That's the one, 2093. That's the one that sets out those trumpets, you know, the sort of broad things that come out with different colours. That's why there are the different colours, because the CAA needs to be told about where aircraft might be up to 7,000 feet, because it's relevant to altitude-based airspace design, which is concerned at those sort of altitudes with minimising CO2 emissions. It's not, as the composite plan suggests, because there are significant noise effects out to that level. And the composite plan is just, in my respectful submission, completely misleading. A, it goes out to 7,000 feet. It is implied that all this area will experience noise failure. Well, these are just design trumpets, if you like, within which airspace will be designed. Thirdly, it's suggested, indeed, that in some way this is related to significance. It's clearly nothing to do with significance. Even Lowell is not the level for onset of significance. It's simply at the lowest level at which there are observed adverse effects. And this was indeed produced for the purpose of the composite parts of it from which it's been made for the purposes of airspace design. And Collins Anbury's third witness just adds nothing useful on this at all. His comments about N65s as a noise crank just doesn't take things forward at all, I'm afraid, and therefore I do invite you to give very little, if any, weight to that particular document. Now, where did the Divisional Court end up on all of this? The Divisional Court conclusion, paragraph 179, simply to take us back to Mott. So I'm reminding us there, they weren't at that point, they're dealing with Mott at 179, and at 491, they again bring us back to Mott. So 491. Where they are dealing with the Hillingdon submissions on this. Bottom of page A5, won't read the first bit, but they say, we agree with Mr. Morici that it's inappropriate to ask this court to adjudicate on technical differences of this nature in an application for judicial review. Mott again underscores this point. There was nothing that could be described as irrational in the Secretary of State's approach to the selection of the noise parameters. This issue did not involve any failure to comply with the SEA directive. That is, my respectful submission, absolutely correct. My Lord, I'm too conscious of time, and
How much longer do you need?
2 or 3 minutes, I would think.
You have 2 or 3 minutes.
My Lord. Finally, on my fourth area, relief, I will address you in relation to the earlier cases on relief. On the HRA issues, we say the point is straightforward. If the challenge succeeds on one of the two HRA grounds, hub or mole gap SAC, but not the other, then relief should not be granted. I accept that if Hillingdon had succeeded on both of those grounds, hub and the mole gap point, then I don't advance a case that relief should not be granted. On the SEA grounds, those that go to relief, so not the standard of review, which is a challenge to what the divisional court said. Relationship with other plans, my lord, I rely on what Mr. Marici said in his submissions just before I started about Ursula Stevenson's evidence, and particularly that part of her evidence that started at paragraph 3.45. We don't need to look at it, but Mr. Marici has all the notes in his SEA note at paragraph 36, and the effect of Ms. Stevenson's evidence was that, look, even if we had taken into account all the individual plans, this would not have made a difference to the decision making. And in that context, we say that it's highly likely that the decision would have been exactly the same. Relief should not be granted. In relation to the environmental characteristics of the affected areas point, the noise point, we say on that whatever the precise dB level that is used for a particular outer contour, the message in the appraisal of sustainability was absolutely clear, which was that the Northwest Runway scheme had very much greater impacts on noise, in terms of noise, than did the Gatwick Runway 2 scheme. And simply drawing the contour in a slightly different way doesn't actually alter that fundamental point. It's clear when you look at the ANPS itself. I'll give you some examples. Paragraph 3.50, 3.70, 3.72. That again, the government knew and acknowledged in the ANPS that the Northwest Runway scheme had greater noise impacts than Gatwick Runway 2. And I emphasise this point, which may seem slightly counterintuitive, but simply going to a lower noise contour doesn't actually make the noise any greater or lesser. If you think of a noise contour a bit like a height contour, you can look at the size of the 100-metre contour, the 200-metre contour, and the 300-metre contour. Whichever of those contours you look at, the hill is still the same size. Whichever contour you look at in terms of a dB level, the noise is different. And these are contours that were being looked at by experts. They understood what these contours were to be used.
So the noise is different. Do you mean the noise is not different?
The noise is not different. Sorry, did I say?
You missed out the not.
I do apologise.
But we understood you.
Thank you. The noise is not different, just as the hill is not different. It's simply the point at which you are measuring. The further you go out, the less effect there is at that particular outer contour. And so again, we say, look, this is at its highest, a technical breach of the SEA directive. That the decision would be exactly the same because the government acknowledged that Heathrow had greater noise impacts, and therefore it's highly likely again that the decision would be the same. And in relation to the FOE and Plan B Earth challenges, I made my submissions about public interest, the importance of having clear policy framework, and you've seen from Mr. Marici and indeed myself the importance and the urgency of there being further airport capacity in the southeast. So, my lord, in the round on my fourth point, I submit that it is highly likely that the decision would have been the same and the relief should be refused. My lord, those are my submissions, and once again, I'm terribly grateful to yourself and indeed others. I suppose I also need to say, may I be released, and that with not intending at all any discourtesy to either yourself.
It's a dangerous question.
Either to yourself.
But the answer is yes.
My lord, after the short adjournment, Mr. Jerry Pacino, who's dealing with the hub claims, will be sitting in this place, but Mr. Turney, my very able junior, will be here if anything does arise.
Thank you.
Thank you.
Thank you. you very much, Mr. Andrews. We, for our part, are grateful to everybody for accommodating those submissions and for our sitting late into the short adjournment. We shall take the full hour, however, and return at 2:15. And Mr. Banner, you will then be making your submissions.
I will be, my lord. I'm not sure that Miss Marici visitor is going first.
Still got half
She
an hour.
is.
So you are, yes, forgive me.
Well, there is an issue about given where we are on time and how much we've got to do today. In theory, the hub case is supposed to be starting this afternoon, but just looking at the clock and thinking that's looking a bit unrealistic.
And you're suggesting that we ought to alert
Well, my lord, yes, because we've
them.
come back at 2:15. I think we've got an hour and 45 minutes in total, so I've got half an hour, 15 minutes, it's an hour, yes, hour and 45, so that's 4 o'clock. We have to change over because there's a lot of papers that have to come in and out. It'll probably take 15 minutes. By the time we do that,
No, you're right.
Raising whether it's worth.
You're right. So, I think, should start at 10. We should start at 10 tomorrow, and I'm going to make that decision now to help everybody. We will start at 10 o'clock tomorrow morning, and I think I shall be in time to ensure that the list, the cause list, says that. If it doesn't say that, then please pay attention to what I'm saying now rather than to the cause list. We will sit at 10 o'clock in the morning.
10 o'clock tomorrow, and that's when
Tomorrow.
the case will begin.
Yes. And we shall alert those involved in the hub case to that timetable.
We shall try and do the same.
If you would, that would be kind, but we shall take our own steps to do that. Thank you. Then 2:15.